NLRA Section 9A states that a union chosen as representative by the majority of employees in a bargaining unit is the exclusive representative of all employees in the unit for collective bargaining purposes. Glenn belonged to a bargaining unit represented by a union. Glenn didn't support the union and had voted against it in the representation election. Could Glenn meet individually with his supervisor to negotiate his own terms for salary and benefits? No, he couldn't. If a union represents a bargaining unit, whether by certification, voluntary recognition, or a bargaining order, then only the union may negotiate with the employer over the terms and conditions of employment. Glenn belonged to a represented bargaining unit, so Glenn couldn't deal directly with his employer on his own behalf regarding his wages and benefits. NLRA Section 9A prohibits direct dealing, meaning negotiations between employers and employees about employment terms and conditions without union involvement. This exclusivity rule prevents employers and employees from undermining collective bargaining by circumventing the union and negotiating directly. The rule may seem unfair to employees like Glenn who don't support the union, but Congress determined that this restriction on the minority's wishes is an acceptable cost of institutionalizing collective bargaining. Suppose that Glenn and several other employees in the bargaining unit complained of racial discrimination in assignments and promotions. The union filed grievances based on these complaints because of a provision in the applicable CBA that expressly prohibited racial discrimination. Glenn wanted the union to do more, but the union refused. Glenn and his co-worker Alice began picketing the employer on their own initiative without the union's approval. The employer fired Glenn and Alice because of the picketing.